Well, let's just jump right into it.
Perfect.
Kirk, thank you for being on the show.
Glad to be here.
So it's an interesting topic because I think for lawyers, this is just common ground. They understand this very well, but you start looking at the market, business men and women, they talk about this topic quite frequently, or they discuss it, but ultimately I don't always think that they understand what they're getting themselves into, right? They say, hey, I want to sue this person, but what does that really mean?
Yeah, or we'll have potential clients come to us and say, hey, look, I've been sued. What do we do? They're a small business owner. They don't really know what the steps are. They don't really know what to expect. They just know they need to do something. They need to have counsel representing them.
Right. They're mad. They want to take action. Knee jerk. Let's sue them.
Yeah, and I think part of our role is to kind of inform them up front, walk them through the process, which we'll do a little bit today, but then also kind of help them understand that while they may be mad, they need to kind of approach things from a less emotional standpoint. And that can sometimes be hard because these lawsuits can deal with things that are very personal for them. Their house, their kids, their business that they've poured a lot of blood, sweat, and tears into. And so it can be very emotional, but part of our job, again, as counsel is to help them be a little bit more objective, a little less emotional in how they're approaching things.
Yeah, it's clinical, right? You almost have that clinical approach, at least initially, looking at the problem, figuring out what is the best way to get to that resolution. So let's start with just the statement, I want to file a lawsuit. I want to sue. Now, in a lawyer's mind, that's not where you start on the analysis. I think the analysis starts as, are you even able to file a lawsuit? Is that the first step? Is that the opening move?
Yeah, and normally the way I'll approach it with clients or potential clients again is, what's going on? Why do you want to sue? What's the issue? And really what it comes down to a lot of times is, how bad is the conduct and how bad are the damages? Because sometimes people will be treated badly and they may have claims that they could bring, but they don't ultimately have any damages. There really hasn't been anything that has happened to them.
Right. So it almost becomes twofold, right? I believe it's a legal analysis, right? Can they sue? Can they file suit? Or do they have to start with mediation? Is there a prerequisite before they can actually file? But there's also that economic analysis, right? Does it make economic sense to initiate litigation?
Yeah, and look, that's part and parcel to the emotional component of this is having them focus on the cost too, because what I like to tell people all the time is lawsuits typically take way longer than you think they will, and they cost a lot more money than you think they will, regardless of which side you're on. Now, there are certain types of law, like personal injury, where maybe you get a contingency attorney, so it's not really costing you anything out of pocket at first. We don't do a lot of that at our firm, but there's definitely a cost component to pursuing a lawsuit. And, that's something you got to consider, as well as the time and stress that's involved, because while hiring an attorney, you can kind of put a lot of that on the attorney. And that's part of what we deal with is helping them understand the steps, helping provide recommendations and strategies so that can kind of defray some of the anger or frustration that they feel that never totally goes away while the lawsuit's pending, just because it's a stressful process.
Right. Well, I think you hit a good point. When you hire a lawyer, largely you're taking that stress off of the individual, and now it goes onto the law firm or the attorney.
Yeah.
Right? There's a shifting of that burden, which I think to a large extent, a lot of clients after they hire a lawyer, they feel better because it's in someone else. They're outsourcing that problem.
Yeah, absolutely. I mean, look, anybody that's contemplating suing someone or has been sued, you need to get counsel or you need to talk to somebody. It's tough to do it by yourself. Even if you're trying to save money, oftentimes you're going to end up paying a cost at some point, even if you're trying to represent yourself or you're getting a free attorney that may be a buddy that doesn't really know what they're doing because it's not their practice area.
We see that a lot. Yeah.
Yeah, 100%. Where it's a civil suit that is related to a real estate transaction or your HOA, for example. And so you have a buddy that does family law and she comes in and is trying to guide you through the process, but she doesn't really know real estate or homeowner association law. There's things that you need to be aware of. And so you really need to hire an attorney that's kind of got a specialty in that particular area.
No, I agree. It's one of those, you get what you pay for.
Yeah,
right?
Certainly. And if you try to represent yourself, it's the old adage that, somebody who's representing themselves has a fool for a client.
Right.
And that's true whether you're an attorney or not. It's always better to have some outside person that can give you the outside perspective.
Without question. Okay, let's get into it then. So this notion of filing a lawsuit. Let's sort of break it down mechanically. So let's say you're at the point now where it's viable from a legal perspective, it's viable from an economic perspective, it makes sense, those are aligning. From a lawyer's perspective, what are the steps? What are you looking at from start to finish? Let's break that down. I think that's important.
Yeah, no, 100%. And one thing to keep in mind is it kind of depends on what kind of a suit it is. So if you're dealing with a homeowner association dispute or a real estate transaction dispute, you may have a pre-lawsuit mediation requirement. So you need to make an attempt to reach out to the other side to try to resolve things informally or attend a mediation with the mediator. And what that is essentially the parties on both sides hire somebody to act as a mediator between them. You pick a date, everybody shows up. More and more these days it's being done by Zoom. But then you work with a mediator to see if a mediator can resolve things. And there is some cost involved because typically you'll have an attorney involved at that point. You'll be paying for the time of the mediator. But it is way less expensive than a full-blown lawsuit.
And then I think the other thing too is, what is the consequence of failing to hit that step? Because we've been in situations before where clients have come in, they're halfway through a lawsuit, and we realize before they initiated the lawsuit, they didn't check that box. So what is the downside of not hitting that mark?
Yeah, and again, that kind of depends. So like in a homeowner association context, it's not fatal to your lawsuit or fatal to the claims you're bringing. It's not going to be a basis for the other side to try to kick your suit out, but it can be a factor that judges will look at the end of the suit in deciding whether or not to award you attorney's fees. So let's say, you file the lawsuit, you go all the way through trial, you're 100% successful, you win your suit. The judge is then evaluating whether or not to award you attorney's fees. That could be a factor that a judge will look at in deciding whether or not you're entitled to your attorney's fees. And a judge may ultimately decide, hey, look, had you gone to mediation, this probably could have gotten resolved, and I don't think you in good faith made any sort of attempt, and so I'm not going to award you your attorney's fees.
Yeah, I would argue it is always best practices to hit that mark before commencing litigation.
Yeah, and look, it's not just because you want to maximize the chance of getting your attorney's fees back, although that's a good idea. Part of it is just very pragmatic, and I tend to be a very pragmatic litigator, which is, look, if you have an opportunity to resolve this before you spend a whole bunch of money on a lawsuit, why wouldn't you want to do that? Even if there's a lot of acrimony, it's worth maybe paying for some mediator time and spend 4, 5, 6 hours with a mediator, seeing if you can come to some kind of middle ground and get it resolved that maybe you're not 100% happy, but you're going to be happier. It's going to be resolved. You'll have finality, and you can kind of move forward from there rather than tying up, 2, 3, 4, 5 years of your life in a lawsuit.
No, I agree. A good mediator is worth their weight in gold, without question. So, okay, now let's fast forward a little bit. You're through the pre-litigation phase, if there is one. Now you're looking to file. What are the considerations? What's step one?
Yeah, so as a plaintiff, step one really is preparing and filing a complaint. So whoever your counsel is going to prepare the initial document that's going to be filed with the court that's going to outline the general facts supporting your case and the causes of action that you have. It's also going to identify all the parties that you're looking to bring into the lawsuit as well. That's on a formal-looking document. It's got what we call a caption, so it has the attorney name at the top. It's got the parties in a little box. It identifies the causes of action that it's a complaint, and then there's little numbers on the side of the page that show line numbers. It looks very, very legal-like.
Right. That is a true legal document.
Yeah,
I would say.
Yeah, and it just outlines all the general facts as you're aware of them and the causes of action. And you're not necessarily going to put in every fact or every issue because you're really going to put the focus on what's relevant at the time and what you're aware of. And you may become aware of later facts down the line, and we can talk about that in a minute.
Yeah, no, that's a good point, because I've seen this before where the client's expectation with the complaint is that we're getting everything in front of the judge right out of the gate, right? It's almost this misconception that the complaint is going to the judge and saying, here's all our evidence, can you make a ruling? It's far from that. I mean, it couldn't be further than the truth, but there seems to be sort of a confusion in the market that the complaint has to embody everything, all of the details, all of the evidence, and that is, the judge is now receiving that, looking at it, and is going to start making decisions right out of the gate.
Yeah, and look, in California, it's a notice pleading state, which means the intent is really to just put all the parties that are going to be on the other side on notice as to the general facts and the claims you're making against them. all the specifics and the details are going to be sorted out during the discovery process, and we'll talk about that again in a minute. But the complaint is to really establish the general framework of facts that you're working from that support your causes of action, and then the causes of action that you're bringing.
All right. So we're at the phase now. Complaint's been prepared, filed, then what?
So then once it's been filed, you'll get what we call a conformed copy back from the court. This is very detailed, but the court, marks it as being filed. It's usually assigned a case number and a judge or a department. Once you have that, then it's ready to be served. So then you can give it to a process server or however you're going to serve it, but then you got to serve it on all the parties that are defendants. That sometimes can take time.
That can be a nightmare, right?
It can 100% be a nightmare because you might be dealing with individuals who are constantly moving around, whose addresses are not known. If you know where they live and you know where they are, it's pretty easy to serve. Or if it's a business, a formal entity in the state of California, the information for how to find them is on the Secretary of State's website because they have to list what's called a registered agent for service of process, and it has a person's name and their address, so you know where to serve it. It gets a little trickier if it's a person who's kind of bouncing around.
Yeah, let's talk about that real quick. Someone who ducks service, because that's always it's not always an issue, but I see it frequently. Someone just doesn't want to get served, so they duck service, meaning process server shows up, knocks at the door, they're home, but they're not home, right? So what is the process there? How do you serve someone who is evading service?
Yeah, and there's probably each firm kind of handles things a little bit differently, but generally what you do is you'll hire a private investigator, you'll hire a very specific kind of process serving company. And I mean, they'll get, very private investigatory on them. They'll stake out their house, they'll follow them to work, they'll see if they can catch them walking their dog on the street. It's not like the movies where, somebody like pops up magically in a random spot and then stuffs an envelope in their hand, although that could happen. It's typically that they'll find out where they're going to be and then they'll just go serve them wherever they can catch them. They're normally not quite as creative as, TV or movies would have us believe, but that's really what you got to do. You got to pay somebody to go track them down and then serve them.
Yeah, I think the visual is Pineapple Express with Seth Rogen.
Yeah.
And he is, I think his job is a process server. So he's like a pizza delivery. He has all these outfits in the back.
Yeah, and there are certainly people that will do stuff like that.
But that's sort of extreme. And
that's sort of extreme. I mean, more often than not, you just hire a good private investigator. Because look, part of the trick too is finding some of these people. Sometimes you know where they live or where they lived, but they're gone. And so you'll need to get a private investigator that can kind of track down, potential mailing addresses, and they have ways that they can look for them. But it can take some sleuthing to figure that out.
And what if that never materializes? What if they don't get served?
Well, there's other ways you can serve them. So you can serve them by publication. That's another option.
Yeah, explain that real quick.
Yeah, so you can effectively ask the court for permission to serve them by publication. What that means is you just have to put a notice in a newspaper essentially saying, hey, so-and-so, we are trying to locate you and serve you with these litigation documents, like an ad in a newspaper, for example. And usually like in the classified section, and this is a little weird now because there aren't a lot of written newspapers, but there's online forums and things like that to serve them. And that's really what you do is you just put a notice somewhere that this lawsuit is pending against them, and that will count in trying to serve them. The same thing can happen with businesses. So sometimes businesses have a registered agent, but you go to serve the registered agent, and that person's not there. The location's empty. They haven't updated their information. And so you can get permission from the court to serve the Secretary of State on behalf of the entity, and it's effectively like serving the company.
Gotcha.
And that starts the clock on when their response is due.
Okay, so let's get into that. So assuming they're served, whether personally or through notice, then what happens? What is the next chess move?
Yeah, so assuming you serve them, and it can be a nightmare, it can cost some money to do that, but assuming you get them served, then it starts the clock running on their response, and they effectively have 30 days to respond to the complaint from the day that they're served. And their response can take a number of forms. One, they could just straight up answer the complaint, and what that means is they prepare their own very legal-looking document. It's called an answer, and they'll put forward their own facts and their defense. They'll put forward affirmative defenses that they believe justify whatever claims are being made against them. And then that is filed with the court and served on all of the parties that are involved so far. Things get a little trickier if the other side decides they're not just going to file an answer, because they can try to attack the complaint in a number of ways. One, they could file what's called a demurrer. And in California, that's effectively a motion to dismiss, where assuming everything in the complaint is true, there's still some legal basis for them to be out of the suit, or that the claims don't apply to them. That could be a stall tactic or a way to run up costs. Parties will sometimes file demurrers just as a matter of course to try to knock something out of the complaint or make the plaintiff's life a lot more difficult or a lot more expensive. The other thing they could do is file a motion to strike. And motions to strike are a little more targeted in what they're attacking. So the demurrer kind of attacks the complaint as a whole. The motion to strike really attacks specific language or specific items in the complaint itself. And you present effectively legal arguments as to why these particular claims or allegations don't apply. For a good example is punitive damages. So a lot of times plaintiffs will request punitive damages based on...
People love punitive damages.
You hear that and everybody sees dollar signs and they think the cash register is just going to open. I mean, there are certainly times where punitive damages apply, but many times they don't. But sometimes, a lot of attorneys will just like to throw that in there if there's even some small reason to get it. Prophylactically or to try to gain negotiating leverage. There's various reasons. But that's one thing you could attack by way of a motion to strike and just say, hey, look, this is not a punitive damages case. There's no malice here. They haven't alleged any facts sufficient to show malice. There's no fraud in play. That's how you attack it to try to knock it out, would be a motion to strike early on. Now, sometimes it can be less than effective because you might not necessarily have enough facts or evidence to really back it up at that point. And really all the court is looking at is the four corners of the complaint. Right. What do the actual pleading documents say? And sometimes that's not enough. I like to be careful in filing demurrers and motions to strike because they can be expensive. They can take a long time to be heard by courts these days, which kind of puts a stall on the litigation moving forward. But it's worth exploring because there are times where it's certainly needed and effective for a client.
Well, I agree. They can be very effective weapons at the outset, but on the other side of that coin, it can be a complete waste of time and resources. So, okay. So here's another question on that, or I guess first a observation. A lot of clients at the opening phase of a lawsuit, the assumption is there's going to be a lot of action, there's a lot of movement initially, sort of in that pleading phase of the lawsuit. But I would argue that that isn't really the case. It's more technical at the beginning, laying the foundation for what's going to come ahead. Because then you switch from, once the pleadings are resolved and any issues, if there's a demurrer, and those are resolved either by the parties or by the court, now you're moving into the discovery phase. And that's where I think when people think of a lawsuit, that's what it looks like. That's where the depositions happen. That's the information gathering. So do you want to walk through that, sort of what that looks like, how you approach it? Because that's really where you get to the meat of the issue.
Yeah, certainly. But let me kind of point out or jump on something you just said that I think is worth keeping in mind is the length of time between when a complaint is filed and when things are at issue and you're ready to kind of move forward with discovery. That can sometimes be months of time. And, especially if you're a plaintiff, you want things to be like moving along quick. Right. You don't want to be waiting. You don't want, you think that as soon as the complaint gets filed, like, hey, we're off to the races.
Right, you're rock and rolling. Right.
And that is frequently not the case. That it will take sometimes months to serve somebody, get some kind of response. They could file a demurrer, and it could take 4 months before the court's even going to hear the demurrer. And so maybe you're 6 or 8 months post filing the complaint.
Before it's at issue. Before
it's even at issue. And even once a demurrer is heard, sometimes courts will say, hey, look, I'll give you plaintiffs, I'm going to grant this demurrer, or I'm going to sustain the demurrer, but I'm going to give you an opportunity to amend the complaint.
Another bite at the apple.
And that's a double-edged sword depending on whether you're a plaintiff or a defendant in the case. Because if you're a defendant, maybe your demurrer got sustained, which means the court agreed with the arguments you were making, but the judge is going to give the plaintiff another opportunity to
right.
fix it.
It's not necessarily fatal.
Correct.
So it's one of those victories where you're like, oh, they ruled in our favor, but now it's a do-over.
100%. And so it's just worth keeping that in mind because, sometimes we'll have clients that get really anxious, to move things along.
Right.
And they think it's going to be quick or that's going to be the hammer that's going to beat the other side into submission. And again, that's why I keep going back to it always takes longer and it's always more expensive than you think because these processes take time. And we, even as attorneys, are at the mercy of the court sometimes. They can't hear it until...
Well, especially now with the COVID backlog, I mean, there's a lot of factors going into why it takes so long.
Sure.
And yeah, to your point, I mean, even to get it at issue, it can take a long time.
Yeah, I mean, there's budget cuts for the various counties too with the courts. So there's a lot of factors that go into this that can delay it. So I think that's a good precursor to, getting into the discovery thing. Just understanding that process can take months before you're even ready to kind of really jump into the main part of the case, which is the discovery process.
So yeah, let's break that down mechanically because again, that can get muddy too pretty quickly, especially if there's bad faith and the other side is playing games. I mean, that can become, just a swamp of the process.
Yeah, absolutely. So look, discovery is the real meat and potatoes of a lawsuit because that's where you're gathering information that you need to support your case or to figure out what the support is for the other side's case and then formulate a way to attack it. So discovery takes a couple of forms. One is writ discovery. And you can serve what in legalese we call interrogatories. They're really just written questions that ask the other side to provide information. And that could be things as mundane as like their name, where they were born, what schools they went to, the names of people that have knowledge about, the various claims at issue, down to very, very specific things for the case, how things happened, where things happened. The other thing that you serve typically are document requests, and those are very critical too. A lot of what we do in the law depends on what's written down in a document. And most lawsuits have documents that are part and parcel to
somewhere. They have them somewhere.
They're somewhere. Emails, text messages, contracts, letters, insurance policies. There's all kinds of documents that relate to whatever the claim is. Title documents, whatever it might be. And the document requests are how you get those. The other side, when you're dealing with a state court lawsuit, isn't under an obligation to just like turn over stuff to you that they think you're going to want. And you don't want to leave that up to them anyways. So you're going to send to them specific document requests identifying categories of information that you want to get from them. And that they can be broad, they can be specific. They're frequently covered with legalese.
Well, let's get into, because that's a good point. So you have a document, it's relevant, you make the appropriate request, and I believe that's where the gamesmanship opens up, right? That's where they say, the opposing side says, no, you're not entitled to it. Privilege, I mean, they'll make an objection. So walk us through that, because that's where this process can go south, or not necessarily south, but it can become very contentious. There's a lot of back and forth. So what happens when one party makes a request that's valid and the other one refuses?
Yeah, so if you make a request and the other side refuses, you are required in the state of California to do what's called a meet and confer. And what that is you are required to either do it by phone or by letter or email. And you effectively communicate or attempt to communicate with the other side saying, hey, look, you haven't complied with your responsibilities with regard to these written requests. You have to do that. And you'll lay out the legal arguments or cite to the statutes, and you'll identify deficiencies in their responses. They didn't provide enough information. They didn't produce any documents that you know exist from other responses. They didn't produce a privilege log for objections based on privilege, and I'll break that down. So, when you're providing responses to this written discovery, the responses will typically include objections, because rarely are the questions that you're getting or the requests you're getting so specific and so straightforward that they're not objectionable. Normally, there's a lot of defined terms. They're defined very poorly. The questions are overly broad, so it's kind of hard to figure out exactly what somebody is asking for. And so you'll assert a number of objections to kind of protect your client's interests and to try to figure out or kind of narrow down your understanding of what the request is asking for as part of the response. And then you'll produce whatever documents there are. It may be that they're in fact asking for documents that are privileged. So their request could be so overly broad in its formulation that they're asking for communications from counsel.
Attorney-client privilege.
Yeah, 100%.
Right.
And so you'll provide a privilege log of documents you're not going to produce because a privilege would apply. And that's required under the code in California. There's a lot of parties that are sloppy or lazy and they won't do that. And so you may think they're holding back documents. And it may be that they actually are privileged, but you don't know because you haven't seen a privilege log, you haven't seen the documents, you know that something exists. Those are the things that kind of create these conflicts or problems. And sometimes if you're dealing with a problematic or difficult attorney on the other side, it can escalate very quickly.
Yeah, let's run through that. You make the request.
Sure.
They tell you to go pound sand. I'm not turning it over. You know it's relevant. You know it's discoverable. You follow up with a meet and confer. Their response is go pound sand. What do you do then? What action do you take then?
Yeah, I mean, at that point, you really have no choice but to file a motion to compel with the court.
Okay.
And so
so that's when the court gets involved, right? That's a huge difference because it's sort of this informal discussion with opposing counsel, but then it changes its nature very quickly over to court intervention.
Yeah, and part of that's allowed under the code for all of these discovery vehicles that you have, whether it's an interrogatory, a request for a document. We haven't talked about it yet, but a request for admission is the same thing. If somebody's playing games, they're asserting objections that aren't valid, they're withholding information that you reasonably believe exists, you can file a motion to compel. And it's, like any other motion you file in a lawsuit, you make your legal arguments in a document. It's got evidence in support of that. It could be declarations. A declaration is a signed affidavit. It's a signed statement from a person saying, under penalty of perjury, I'm telling you these things are true. And you submit it to the court. And frequently that will involve asking for sanctions too. Hey, judge, they are making us waste all this time and money. If you grant this motion, you got to make them pay us back for having to file this motion.
So yeah, let's bifurcate that motion because on the one hand, you're asking for the document or documents, but on the other side, you're asking for sanctions. What do the sanctions tie into? Right? How do you break those down? How do you come up with that math?
Yeah, and look, we could get in like another 2-hour conversation about sanctions.
Let's not do that. Let's high level.
Yeah,
Concord 3,000-foot level.
Yeah, so typically the first sanction that you would request is really money. Hey, compensate my client for making us file this motion to compel because they should have just turned this stuff over to us.
Which ties to the attorney's fees?
Yeah, that's the attorney's fees and costs incurred in filing the motion to compel.
Right.
And in some cases, the actual meet and confer process, but for the most part, it's the motion to compel the responses to the discovery. The intent being, hey, look, we want the parties to work cooperatively in this discovery process to turn over relevant information to each other because that's what helps work towards a solution or a resolution. And so the parties can be prepared for trial. The intent behind the discovery code is the party should not be surprised at trial.
Right.
And nobody wants to have a surprise witness or document just come up at trial that you've never seen or heard of before. Hey, look, I would love to Tom Cruise somebody, in trial or in a deposition, but that almost never happens.
Right.
You're never going to get somebody like a Colonel Jessup that's just going to spill his guts like right there when they're on the record. But getting these documents is about as close as you can get to that because sometimes somebody's going to have sent an email that's a little more candid than what they're willing to say to your face when you're in a deposition maybe.
Right.
Or when they're on the stand at trial. The motion to compel is really to get the court to order the other side to comply with the discovery. And the sanction is really the stick that the court uses to kind of slap their hand for not doing it.
Now you identified two things with the court. They have that huge backlog because of COVID. You have budget cuts. So what's the court's temperament when it comes to a legitimate motion to compel?
Yeah, and that's a good point to raise. They hate them. I mean, judges typically hate discovery disputes or motions to compel because that's the low-hanging fruit, I would say. And so the judges will do almost anything they can to avoid having to address a motion to compel. So you have a lot of departments or courtrooms in Southern California where our office is located that will set an informal discovery conference or have a requirement that you attend an informal discovery conference. Really all that is the judge kind of takes off his robes and meets with the attorneys on the phone or by Zoom or, in his chambers, and, you kind of
hash it out,
sing Kumbaya, so you can come to some kind of an agreement.
Right.
I mean, that stinks for a client because they're paying you typically to be there for it, and then they're not going to get sanctions if you work some deal out. So it's kind of an investment in the discovery or part of the litigation process.
But it almost becomes a necessary evil. I mean, if the other side is playing games, there's only so much you can do informally. Bringing in the court, even informally, it carries weight.
Yeah, 100%. And look, at the end of the day, you really want the discovery more than you want to stick it to the other side. The intent behind the motion to compel is not to try to hurt the other side. It's really just to get them to do what they should have done to begin with. Different attorneys may have different strategies or look at it different ways, but I will only file a motion to compel if it's really just necessary, that like the other side's playing games and they're holding back, because it is expensive. It's not guaranteed that it's going to result in the information that you want, because sometimes judges are like, well, because they hate dealing with them so much, is they'll say, look, I'm not going to grant the motion, but I see the argument you're making, so why don't you reserve more specific discovery and then we'll have the other side answer it. So they'll kind of split the baby, so to speak. I mean, it's not super satisfying to clients because you spend all this money on a motion to compel, they're already deep into this lawsuit, and the judge doesn't give them what you really wanted or what they really wanted.
Right, but I mean, ultimately, if you get the document, if you get the smoking guns that are going to help the case, it's worth it, but you don't have that victory that you were looking for. And I think really it's at sanctions, right? The client wants the check.
Well, yeah, and sometimes it's because they want their pound of flesh because there's a lot of acrimony at that point. Right. And that's why, part of our role as counsel is to kind of talk them back from that, because it's not really meant to help with their vendetta or get that pound of flesh. It's really to get the information that you're entitled to.